All right, y'all. I'm not going to waste any time. I'm just going to jump right in because I do plan on posting this live so people can watch it back from the beginning to get anything that they missed. This is going to be a mini lesson that is very important in regards to the upcoming tax workshop. Happy Sunday, it's Easter Sunday, so if people are celebrating with their families, enjoy that and whatnot. I don't discriminate. But in order to be successful on the sovereign side of things, you need to be able to do a few things. You need to understand how law works in its most basic sense. If someone breaks the law, how do you hold them accountable? With or without an attorney? Because the beautiful thing is, with a lot of the claims that I bring you, they're so solid that you could use an attorney if you wanted to. But much like ChatGPT, an attorney needs to be guided and directed very specifically. And if you are not specific enough with your claims, more than likely you're not going to get the outcome you want. But you need to understand how it works in its most basic sense. Just like how if a cop supposedly catches you speeding, if you get caught up in any kind of traffic violation, the same way that the cop must submit a complaint, the complaint goes to the court. Then the court will adjudicate the complaint. And you're supposed to, in most cases, go through, have a trial. The cop must testify. There's a jury. There's evidence. There's a burden of evidence that must be met. There is a lot that goes into that. And I promise you that 99% of the time, most places do not have the time, nor do they want to expend the resources to take someone all the way through a trial. And not only that, they 99% of the time are unable to sustain the burden of evidence placed on them in such a trial. This is why even people who may not be doing things certain things right sometimes, their case will get dismissed just because the state already knows that they have an inability to sustain evidence. And so when someone is like, okay, I'll play your game, but we're going to go all the way through a proper trial, as is guaranteed by the Constitution, they fold. Because oftentimes it's going to cost them more money to try to recoup the little charge from you than what it's going to cost for them to argue and try to, prosecute you in the first place. It's just not worth it. So, on top of understanding how law works in its most basic sense, the other thing you have to be able to do is research. The ability to research is unmatched, right? If you're reading something and you don't know what a word means, you don't continue past that word. You research that word, the context that it is being used in the sentence, and only once you understand exactly what it's saying do you move forward. If you do not understand a particular section of a contract, of a document that you're reading from the SEC, of an instruction manual that you're reading from the IRS, a publication, whether it be a statute, whatever it is you're reading, if you don't understand it, you need to take a step back, reread it, recontextualize it until it makes sense in a way that you can explain it to a 4-year-old. Now, once you understand those two things, then we can start getting into the more complicated things, such as what's an example? Such as specific remedies based on violations of certain laws. So once you understand how, if somebody violates the law. This is how I file a complaint. This is how I hold them accountable in a court. This is the burden of evidence that I must produce. This is the burden of evidence they must produce. These are the proper procedures. If they refuse documents, if they don't file things within a particular time limit, if any procedures relevant to your case are not followed, then you need to understand how to enforce that. So whether that be specifically, okay, they violated the Fair Credit Reporting Act. Okay, what provisions of the Fair Credit Reporting Act tell me what I can be paid in case something happens? The willful violations, the negligent violations. And it also describes what circumstances, if something is on your report, constitutes a violation. Same thing with the Fair Debt Collection Practices Act. Like, one of the most basic things that always throws me off, and if you had a baseline understanding, you would already know to do this. So if you send in a debt validation and the company just does not respond at all, well, according to the Fair Debt Collection Practices Act, I believe that they have 30 days, but if they do not respond within that time frame, they are barred from further collecting that debt. So if I send you a debt validation in January and in April you file a suit against me, but you never answered my debt validation, I can get that case immediately dismissed based on the fact that you did not answer my debt validation. Anything else in regards to the status of the contract, who got paid, who didn't get paid, all of that becomes irrelevant at that point. Because if they don't respond, they're barred from collecting the debt, period, point blank. So if they have a complaint filed against you, you go in there with a motion to dismiss based on the fact that you sent them a debt validation on this date with registered mail number. It was delivered at this date at this time. They received it and they never responded. Then you put in a motion to dismiss. Here's the evidence. Here's my memorandum of law. Here's the statute from the Fair Debt Collection Practices Act that says if they don't respond, they're barred from collecting this debt. Here's all the evidence that I did that. Here's a bunch of case law that says the exact same thing. Now please dismiss this. It's all about understanding the order of operations. Now, it's very easy to get confused when it comes to this. But I recently saw a video where somebody said something like, there is no magic bank account with infinite money that you're going to get access to. And I feel like I keep trying to explain that to people. Like, even when it comes to private banking, that's not what private banking is. Private banking isn't that I'm going to go in here and I'm going to fill out a few papers and maybe talk to these guys, and then all of a sudden I have access to an account that already has millions. That's not how that works. That doesn't exist. So whenever you see, and this is why it's very important to understand their definitions of things, because anytime you look up sovereign citizen, the biggest thing, they believe that there is magic money tied to, sometimes they'll say Federal Reserve accounts, right? Or TDA accounts, right? Fictitious TDA accounts, right? That's what they say. That is their definition. That is what they say they believe sovereign citizens believe. And I'd say that that's fairly accurate, because there is a lot of people who believe that they have some secret TDA account or some secret account that they have access to that has all this money. Now, even in the event that your Social Security card, right, is the account number, and if you look on the back, the number of the Federal Reserve Bank and then the routing number, right? Even if that's the case, people who have used those funds, what makes you think that you have access or that you have any entitlement to whatever account is there? That is where people's number one fundamental misunderstanding comes from. And I understand how people get there. I do. But then also, after studying for a long time, it already sounds ridiculous. That's why I was skeptical from the beginning. But understanding, no, it's not just a magic account that has infinite money that I'm going to somehow get access to. No. When they removed the gold clause from the Constitution that requires payment in gold and silver, and it says that we cannot emit bills of credit, blah, 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 make anything other than gold and silver tender and payment of debts. But underneath the delegation of powers doctrine, the Emergency Banking Act, the emergency, if you look at House Joint Resolution 192, what do they say? In light of the emergency that requires us to collect all the gold. So they declared a state of emergency. That's the reason why Congress was able to delegate Federal Reserve notes to be used as tender of payment. But a Federal Reserve note by itself is only a promise to pay from the government. But notwithstanding that, so even if we cast that aside, the use of Federal Reserve notes for tender of public and private debts, we're not disputing that. But there is a remedy that comes from this new system. That's what people fail to understand. They had to provide a remedy. Okay, if we're only going to deal in promissory notes from now on, there has to be a remedy for the people if we're taking away their only means of lawful payment. That's why it says it may be discharged dollar for dollar in any coin or currency, which at the time is legal tender. So that is what is most important. What constitutes legal tender? Federal Reserve notes, sure. Federal Reserve notes are legal tender. But what else is legal tender? That is the important part. Promissory notes are legal tender. They have been considered legal tender. Bills of exchange. So this is where it's important to understand the distinction of things. Because it's not that you can't use Federal Reserve notes to pay debts. You can. That's quite literally what they're for. Whether or not us as individuals are specifically authorized to use those is a different story. Because technically, they're only supposed to be handled by the banks. But again, that is a different lesson that it's like I could spend a whole subject on that, but it's not the most important thing for right now. What's more important, hold on, let me catch my train of thought. Help me out. What was the last thing I was saying before that? If anyone, it's on the tip of my tongue. I'm just, oh yeah. So Federal Reserve notes can be used as legal tender, but so can anything else. So that's where the question starts to come in about, okay, so what is the consideration? I want to take you back to the case of Jerome Dowley, because yes, this case was overturned, but what they found in that case, again, was that the bank itself did not loan him anything. They found that the bank created the credit on their own books from his note to fund the loan. So that case failed for consideration. The bank never gave anything up. Now, even though that case was reversed and remanded, and they will say, this is what they will say, in modern times, the act of accepting your promissory note and using it to create purchasing power, they say that that can be considered an act of consideration, right? So if we break that down into layman's terms, in modern day, instead of me going to the bank and saying, hey, I need 50 gold, I promise I'll pay you back, I give them the note, they give me the 50 gold, I go and I spend it on whatever, right? And then I have to pay them back the 50 gold because they had it in an account and they gave it to me. Or in the case that I wanted to buy a car, hey, I need 25 gold to go buy this car. I'll pay it back. And if I don't, you can take the car. They give you the gold. You give it to the car salesman. Now you get the car. If you fail to pay it back, they have the note. They can come get the car. Right? Okay. Now, if we translate that into modern day, if you want to get the loan for whatever, you go to the bank, you give them the note. They deposit that note and create a credit entry for themselves. Right? Now, because they've created this credit entry, they claim that it's theirs. So they do give you access to the money, but first they pay themselves, and then they open up another account and they give you the obligation. That's how they are trying to frame the transaction. And that it's okay because by accepting the note and giving you purchasing power, they are saying that they fulfilled their end of consideration. So if I get a personal loan, they put the money into an account that I then have to pay back to them. But hey, because I got the money or access to it to spend on whatever, they're claiming that they have fulfilled their obligation of consideration. Now, in the case of getting a home or getting a automobile, when you are financing these types of transactions, according to the 16 CFR 433.1.2 and .3, if they are giving you a purchase money loan for a consumer credit contract, it says that the cash advance is received by the consumer for the purchase of goods from a seller who is connected to the creditor. So, if we follow that train, you give them the application. They deposit that with themselves. What they're supposed to do is take the money generated from depositing your note, any of the proceeds from that initial deposit or from the credit that they're so-called extending, and they're supposed to give that to the seller. The seller has now been satisfied, and now the obligation remains for you to pay back the bank because they advanced the money. That is what, if you plug exactly what I just said into ChatGPT, I promise you it'll tell you that's 100% correct. It won't argue with you, not one bit. Now, the way that it actually goes a lot of times is in the case of a purchase money loan, for you to get an automobile, for you to get a home. They say that they paid the seller. The homeowner, the person who owned the house got paid. The person who owned the car got paid. The dealership, right? They got paid. So they're good. They're satisfied. They're taken care of, right? And obviously, because the bank paid them on your behalf, following the laws of subrogation, well, you got to pay back the bank. Now, that's just under general framework. Now, but this is where, again, now we understand, okay, if I normally go get a loan, a purchase money loan, this is how it's supposed to be. Or even if I get a loan, I am supposed to get the money. Depending on the type of loan it is. Either I get the money or the seller gets the money. But as long as there is a credit entry from my application and they provide that credit entry, the bank is considered to have performed. So if we understand that, then things start to make more sense as to why we would have to pay back a bank. It all flows naturally, right? If they performed, right, their version of consideration, if they do that, that's enough. And what ChatGPT will say is the courts argue that's enough. Okay, that would all be fine and dandy, very, very fine and dandy, except there's the issue of the actual note itself. Because they can deposit the note, but the note itself also has value. So what if instead of paying the seller directly, paying you directly as they're supposed to, what if instead the bank kept the initial credit? So the deposit from your note, they kept it. And then they sold the note itself, sold it for a price probably less than the face value of the instrument. Hey, I have this note, and if you buy this note, it's going to guarantee you repayment up to the value of this note and possibly more based on the schedule of interest and everything attached to that. So I'm going to be greedy. And instead of delivering the money to the seller, I'm just going to give them the note with the rights to payment. So that way, I will still collect money from the person through servicing rights or what appears to be servicing rights. And they won't know that they're not actually paying me, but that their money is being funneled to investors who bought certificates in a trust that their asset was later securitized into. But the problem with that is that if you go read any PSA, any prospectus, any public offering documents, it will tell you that the receivables, so this means your credit card bills, the charges, your mortgage, auto loan, whatever, it'll tell you that these receivables are transferred to a trust. All rights, title, and interest, okay? All rights, title, and interest. So that means that the right to collect payment has gone from the bank to the dealer trust, and then the dealer trust distributes that, right? So that is the overarching structure. But again, when they do this, it creates several different issues because only the person who is holding the note or the obligation at that time has the right to enforce payment. So let me pose this question to you. Your note has been securitized, right? Is it the trust who is on your credit report, or is it the purported original creditor? Because if it's the original creditor who's on your report, well, they're claiming that they're still in possession of the receivable. How many of you have been sued by the actual trust that holds your receivable? When have they actually commenced an action against you? It doesn't happen. But in any case, they would have to be the ones. So even if American Express is the issuer, the moment that they sell the receivable and the rights to the receivable as payment to the trust, then only the trust has rights to collect payment, unless it was properly assigned to them. And that means they would need to have an assignment on or before the commencement of the action from the company that was originally entitled to receive. So that's number one. The trust, 9 times out of 10 is not the one who is even accepting the instrument or even trying to enforce the instrument. That goes triple if it goes to a debt collector. If it flows to a third-party debt collector, okay, send me the contract. Oh, you sent me the contract that I signed with the original company who vested their right, title, and interest to this trust. Show me your assignment from the trust to be able to collect this debt. Show that you purchased it from them. How are you trying to enforce a receivable that you're not even holding? How did you buy the receivable from the original company if they're not the ones who were holding it? That is the right to collect payment. So this is why if you understand all of this, I automatically know, okay, so if they're claiming that it went to a debt collector, mind you, every single time that note is transferred, they're probably selling it. So think about it like this. The initial bank, not only do they get your initial credit, they sell your promissory note at a discount. So they get paid off of that. Now, the payment that they get off of the selling of your original instrument is something that you are entitled to, especially because they already did not perform by sending them actual payment. Now, if they're going to say that the note, your note that they transferred to them for less than the face value was payment, then the note was also payment when you initially gave it to them. So where is the evidence of the initial payment from that note? If we have now established that it is a cash equivalent, because if they're going to say that they performed by giving the note to the company instead of actual payment, then that means that the note has equivalent cash value. Now it becomes a different issue. But again, most times they don't have the proper assignment. So if anybody except for the current holder of the receivable, the trustee, the trust itself, is the one on your credit report, is the one filing against you, trying to get judgments, then all of that can be dismissed because they have no standing, and you can prove it by showing steps 1, 2, and 3. And then on top of that, they don't even have the right, most of the time, to transfer the receivable in the first place. Or if they do transfer it, they don't transfer the rights of a holder in due course. Because this is the problem. You can assert defenses against any person who touched that note. So if the note goes through 4 different entities, and each of those 4 entities made money by selling that note on top of the other proceeds that they received from trading it on any other markets, you're entitled to that money. You're entitled to it. Now, since we've already established that all of these things need to be true, right? These things, so if it's not them, only the person who holds the receivable can enforce. Exactly. Because the problems arise after the contract is signed with how they handle your receivable and who has the rights to collect payment. Trying to argue about whether stuff is prepaid, that language, they don't like that language. And it's also slightly inaccurate to say, because it's not like it was, like, in a sense, yes, it is void from the beginning, because there are certain things that they did not do, knew that they weren't going to do. But at the same time, you signed a contract. The issue comes on the back end of how they handled the contract. That's why you're entitled to certain things. So now that we've established that, right? And that's just in the case of a purchase money loan, right? Now, the way that is supposed to work, or another way that it can be interpreted, is that the cash advance is received by you first. Then you pay off the goods and services. So in layman's terms, I'm going to get a car, right? They take my note. They deposit my note. And instead of paying themselves, they take that plus $250. Then they give me a account where I have access to it, a liability account, $250. It matches. I pull it out. Now their books are even because they had a plus $250 from the asset they recorded with the promissory note and a minus $250 from when I took it out. Then I can take that $250 to whoever I'm buying the goods from, whether it would be a house or a car, and pay them off. Now everybody's happy. They got their money. I got my money. The bank's books are balanced, and I should receive the property. Now, if you're thinking, well, this isn't fair to the bank, well, you're incorrect, because what does the bank still have in this case? Your promissory note, which they can still trade and which they can still sell. Probably not for the same price because they don't have the payment stream coming in, but when it matures, they still are going to be able to get money and earn interest off of that. So they are still left with something of value, but instead they don't do that. They don't pay you. They don't pay the company. They pay themselves and keep your money. Now, say that they took that money and they did pay the company directly. It's still your money that they used to pay the company. But even if you forget about that, let's say they do pay the company and that is considered their consideration, they probably also have securitized your note anyways and lost the rights to collect payment. They have probably created a break in the chain of title that makes that obligation unenforceable. So even if you want to look at it under the standard frameworks, what they do with your receivable after they get it 9 times out of 10 is going to constitute a breach because they always securitize it. Now, let me take it to another layer because, again, you got to understand all of this. And yes, all of this is relevant to the tax workshop I'm about to have, because if you don't understand this, then when I get in there and start talking about the taxes and how all of that relates to this, it's not going to make any sense. So even under the traditional frameworks, the moment, let's say that the dealer was paid, they still securitize your note. Now the issue becomes who has the right to collect payment and if they divested that interest at any point, if they can prove that chain of title. And in the event of a loan to yourself, it's essentially the same thing. If I'm going to a bank and say, hey, I want a personal loan, they deposit my asset. They're supposed to give me the money. I'm good. They're satisfied. I'm satisfied. They have the note. But instead, they pay themselves with the money from your deposit and then write a check to themselves and then make you pay that back. So now you're paying back the money that they owe, as well as giving them interest, and they're trading it and they're doing all of this other stuff. So they're getting paid multiple times over off of your one promissory note and still collecting money from you. Now, like I said, in the case of a purchase money loan, if they just give the note itself, that can fail the consideration. So now you can make claims against that debt because, okay, what was the consideration? What did I receive? Where's the evidence of this advance? That's where the accounting comes in. Because if they are claiming that they are the ones who are the creditors, see, this is why it's important to understand. Okay, if you're a creditor, if you're a holder, you have right to receive payment. If you are misrepresenting yourself as someone who has right to receive payment when you don't, that is illegal. That's illegal. Hey, you owe me. I'm telling the credit report people that you owe me, but really you owe Jim. And all the money you give to me, I'm giving to Jim. Because Jim already paid me when I gave him a promise. You see what I'm saying? So that's what it comes down to. Every single time. They're misrepresenting themselves. This is why if they're bringing suit, if they're on your credit report and it is not the holder of the receivable, it doesn't matter. Then on top of that, whoever transferred the note, if the note was not transferred properly, it's null and void. So let me give you another perfect example. Because let me tie you into how it actually works, because this is going to start making a lot more sense for you. Now, when you get a house and a car, right? Underneath how I just described it, the bank pays them, somebody pays them, you get the property, right? And then the bank has a lien. The bank has to have something to secure their right to payment. That's what a mortgage is. A mortgage is what secures any one company's right to payment. So the mortgage must follow the note. If the note moves, the mortgage got to move. Your servicer got to be updated. Now, the problem is that MERS as nominee for whoever the original lender is, sometimes does not have the authority to even sign to make those modifications in the rare case that they do record a change. But let me tell you what I've seen. So for a mortgage, right, I have literally seen in the securitization report, I have literally seen this, So the type of trust that mortgages get securitized into is called a REMIC trust, REMIC. It stands for real estate, mortgage, investment, like conduit trust. REMIC trust. You can go read the REMIC trust rules and act and all of that stuff. But it is a REMIC trust. The REMIC trust has a closing date. That means that outside of that closing date, if you try to assign something to the trust outside of that closing date, it's impossible. So tell me how I've seen mortgages where the trust that it's assigned into, the closing date is in 2003, but the mortgage was supposedly transferred into that trust in 2010. This is why I tell y'all it's physically impossible, because they would need to produce an assignment on or before the time that the trust closed. How could they transfer a mortgage that didn't exist 7 years prior into the trust? They don't have the proper assignment. Not to mention, once your note moves from the sponsor to the depositor, to the originator, to the seller, to the trust, all of those need to be recorded assignments. If there isn't an assignment for the depositor, for the sponsor, for all of them, then there's a void in your chain of title. Because at that point, your note went one way, was securitized into a trust, and then the mortgage went another way. Now, what's even crazier about that, the note going one way and the mortgage going an entirely different way, is that when the note goes off by itself and it becomes unsecured, once the note is unsecured, nobody can collect it. It's unsecured. There's no documents evidencing who has rights to collect it. No one can be a holder in due course. This is why if the notes are transferred improperly, it says that the consumer may have defenses of recoupment against the trust for any claims and breaches arising from the transfer of the receivables. That's what it comes down to. From the transfer of those receivables. So, to continue on with that, in a mortgage, for example, the note may pass through several entities, but whoever is last listed on the deed is the one who gets the chain of title. Now, in the case of, it's the same thing with an auto loan. They're supposed to have a title, right? Now, if there was already a title on the vehicle or a lien on the title, right? So let's say that the dealership already bought these cars from the bank, which we know they do. Or the trust that they are securitizing this stuff into already has a lien on these assets. So what happens is, when you go in there with your promissory note, again, they sell your note to the dealer who passes that on to their trust, and they use you to pay back the money that their investors need to be paid, instead of the money flowing where it needs to into your accounts and to settle the payables and receivables. It's how they transferred the notes. Just because they didn't disclose to you how they were doing it, or if you didn't understand, that's really our fault and not theirs. But if they already had a pre-existing lien, then when they transferred it to you, that creates issues with the title. That's where the whole bona fide purchaser defense comes in. You guys already had a lien on this. I'm simply satisfying a debt that you already owed while you are collecting the payments from this note and trading it on secondary markets and earning interest that way. Now, this becomes even more of a problem for mortgages when it says, hey, we're not going to trade these on the secondary market, or these securities won't be traded there. But then they transfer it into a private placement trust. And so that security ends up being traded on those markets. But now that becomes an issue of tax, because they're not reporting the transactions properly to the IRS, and they're moving things into a trust to try to abuse tax obligations. Or the fact that they're trying to transfer your notes into a trust whose closing date was 10 years ago. But even if we remove that, if we remove the idea of them having a lien on any collateral, and we just go back to the basic idea that would apply the same for a credit card, which is that once they transfer that payment stream, they don't have a right to collect from you anymore. I promise you, 99% of the time, it's not even going to be in the name of the person who holds the receivable. But this is the most kind of the overarching thing here. If the person who does hold the receivables, for some reason, had the balls to try to bring any action against you, that is where you have full authority to request the full accounting and the performance. Okay, I need to see what the money trail is, who got paid, when and where. And I need to know if this obligation was already satisfied when you sold it the first time. And then if it was, how much are the total proceeds generated off of this, especially if the sale of that note the first time was improper, and therefore none of them can establish a claim to hold it. Now, the tie-in to the tax part is this. When they sell your note, when they transfer it, which we know that they transfer it, you need the accounting to show that they transferred it. Because again, if they didn't provide payment for your mortgage and they kept the money, you can get the loan dismissed for that if they only sold them the promissory note. This is why it's important for you to understand what your rights are, because if you don't have any. But not only that, what is it called when an asset of yours is sold for less than the face value? OID. Not to mention, the same rule applies for the closing date of the trust for credit cards. If your asset was securitized into a trust pool whose closing date was 4 years ago, and you just got the card this year, then it's impossible for that to have been properly assigned into the trust. Impossible. So this is why it's about understanding what evidence you can ask for. Original issue discount. When a security is sold for less than the value of its face, it's called an original issue discount. Now, the other tax tie-in. Your note is your property. Your note is your property. I'm going to say it one more time. Property. Your note is your property. Intangible or tangible. Property can be tangible or intangible. What is an example of intangible property? Maybe an account that I have somewhere? Could that be intangible property? So if I have a property interest in something, I do believe that there is a form that can express my property interest. If I have an original issue discount interest in something, I believe there's a form that can help me express the fact that I am the issuer of an original issue discount instrument. If I give any type of instrument to a financial institution and they use that to generate more proceeds for themselves, there's a form that I can use to represent that barter of information. And if my note is sold If the note is sold for an OID and they accepted payment for it, if whoever financed the loan accepted payment for the sale of your note that extinguished the previous obligation, you're also entitled to a 1099-C, a cancellation. Now, if I was a company who was lying about the status of my deposits, misrepresenting the money that has been given to me, and someone filed the proper tax forms to report how much money they gave me, when they gave it to me, or with an expressed idea that it should be canceled, and then the IRS starts looking and they can see these transactions, but I lied to the IRS and told them that these weren't securities. I told them that I already paid this person out. I made it look like I did everything correctly. Well, then that might cause problems between them and the IRS, especially if certain things were already to have been done. So if I know why I'm filing a certain 1099, which I will be going over because I'm going to be reading specific IRS publications and IRS tax form instructions. That's what we'll be going over. But when I understand why I'm filing all of these things, what credits I'm due, why I'm due those credits, where the credits come from, how to properly put those onto a 1040 or whatever tax form I'm filing, then I won't have any more questions. But y'all have to understand, every single one of your obligations that you have needs to be reported on your taxes in one way, shape, or form. It is a reportable event. So you must report it. Once you understand what to report and why to report it, you'll never have no more problems. It'll be impossible for you to have problems. So, there's remedy to be had on the tax side because of how they're falsely representing things. There is remedy to be had in understanding that if this was securitized, only the person who's holding the receivable has the ability to come after me. It recognizes there must be proper performance and that if money did not move between parties, then it fails for consideration. You can use the language that it's null and void from the beginning, it's fraud. Yes, all of that is true. But the way that that expresses itself, it's probably just a little bit better to say it differently. Our problem is, or at least from what I can see, a big problem is simply the words that we use and how it's just generally interpreted versus underneath a specific framework with a certain understanding. What form is used to report child support payments? So, your framing is just a bit wrong on that. I mean, if I take your question at face value, 1099-C, but that's you receiving that back is different from you reporting the payments. That's just number one. So you trying to do a process to get money back is different. But for something like child support, if you're paying child support, that means they found you guilty of being a non-custodial parent. When was your trial? You didn't have a trial. So that is automatically null and void. So, and with that automatically being null and void, child support is a reimbursement program. The court would have to demonstrate that they paid child support benefits to your baby mother that they paid her. See, they're not supposed to collect money from you to pay her. Child support means we paid her, and now we want money back from you. Okay, so what aid did you provide to her then? If you claiming that I'm guilty, otherwise we got to go to court. And if you weren't properly served, then you need to address the fact that you weren't properly served, because it can't go any further than that. It can't go any further than that, brother. If you weren't properly served, it's out of here. Over with, finito, wraps. You just have to prove it. And it's not that hard to prove. How do they prove it? Okay, if I'm telling you, if you've ever been in a court situation, they'll tell you, here's your charges. And they'll list the statute that you violated, and the statute will say, any person who does this, it shall be unlawful. Okay, so let me go pull up the statute for what they did, and I'll do it right back. And I once heard somebody say that they were the president. Didn't mean I believe him, though. Usually I don't believe people unless they make a claim with evidence, because I hear a lot of things. And I said that to a judge one time. We were having a conversation, and the prosecutor made a statement, and I was like, and I'm the president. Now, we can both keep talking, or we can actually provide evidence to prove what we're saying. Should have seen the look on their faces. It's just common sense. And in your evidentiary hearing, make sure that you prove that you weren't served properly. You do that, they can't go forward. Not only that, look up the child support statutes in your state. I'm telling you, you have to be guilty first. They have to have provided aid on your behalf and are seeking reimbursement, or found you guilty of being negligent. All of which they cannot do without a trial. Your OG got a check for over $300K. That's what's up. What do you mean, how do you pull the 1099-C you filed in 2024, which is on your transcript? Okay, but what money? The question is, what money? What you already paid into it is different than any money you're trying to claim back from the IRS based on the 1099-C. Well, the credits from the amounts already paid are something different. It's all right if you join the tax class that I'm doing. If you catch the tax class that I'm doing next week, you will understand why that question doesn't make any sense. Because I can guess at what you're asking, but in short, the credit that you would be creating through tax forms, you need to file more than just a 1099-C in order to create an additional credit if you wanted to recoup it. I'll put it that way. Or you'd have to include a statement with your tax return explaining why you filed certain things the way you did and how you want them to process it. So, again, there's no just money from a 1099-C that you're going to get back. There's no just money from a 1099-A you're going to get back. It's about why you filed them and how you report them. That's where a lot of y'all get confused. Oh, if I do this, it's going to add money here, and then I do this, and then I pull the money. No, there's a reason why if you file certain things, you can accumulate a credit. But that's why my number one question that I ask people is, what credits are you talking about? What credits are you talking about? And I will say that if you go back once this live is done and posted and you listen to everything that I said, you'll probably be able to pick up and understand what exactly you would need to file in order to get anything back. And also why you're entitled to do that based on the classification of what you gave them. You getting back credits from the judgment order will be something different. Again, if we're talking about money that you pay into a company or that you pay into whatever, and then you later find out that you didn't have to, you have to go through the company or the agency to get that money back. That specific money. Money that you're getting back from the IRS is different money. It's different money than the money that you already paid in. It can be enough to recoup what you paid in sometimes, but the process of getting that money back would involve taking whoever that entity is through the proper administrative process. Now, I'm going to break it down more in the class when talking about the tax forms, because like I said, this is kind of just a pre-lesson that, people should watch before they plan on taking that, because I'm going to expound upon a lot that I covered in here. But in essence, when you are doing IRS processes, you have to understand what the credit is and where it's coming from. So, in the case of any type of transaction, and it talks about this in the withholdings and reporting and stuff that I'm going to go over in the IRS publications. But essentially, off the top of my head, when you are, so a company, it specifically says this in the 1099-A instructions, 1099-C, I think even on the B, it says that if a company or a REMIC trust, actually, it specifically says a REMIC trust on one of the, on one of them. I don't remember which, because I was looking at a whole bunch of stuff. But it specifically says that if a REMIC trust fails to file the proper 1099s, then there's no liability that can be attached to them for that. But at the same time, in those prospectus documents, they say that you are the ones who are going to be responsible for the tax obligations. And so a part of what you are taking care of when you're paying them back is their tax obligations, which they're trying to put onto you, which is why if you report these transactions correctly, the taxes fall back onto them. But if you don't report anything and they report it wrong, then the IRS can only go off of what they get to do or what they say. It's the same thing with your W-2. Your job gives you a W-2. If you agree with the W-2 and file it, then the IRS says everyone's in agreement. We're all good, right? That sounds perfectly reasonable. But if that's not the case, then that needs to be reported. Otherwise, they get to control the outcome because how they file their taxes, how they qualify the transactions as a gift. Again, we're giving them gifts, y'all. That's why they call it estate and gift taxes. We're gifting them instruments with no rule of how to use them, just blank endorsement, no limited usage, just whatever they want to do for the most part. And even then, they still mess up by not following their own processes. But you have to understand what type of account creates what type of obligation and why. That'll tell you what tax form to file. And if you understand that you can only get money back from a withholding or from an overpayment, then it would stand to reason that you need to find a way to increase your withholdings and or make an overpayment, whether that be through bill of exchange, voucher, etc. You don't even need a 4852. That is helpful for the 1099-R, and it is a W-2 correction form. You could do a W-2C, W-2 correction form. And if you Google Form 4852, they're not hiding it anywhere. It's just right there for real. But anyways, y'all, that's pretty much the majority of what I wanted to cover for right now. I'm going to post this, give everybody a chance to watch it, go back and review it. It's going to make a whole lot of sense. It's all about how we frame the obligations. But our lack of understanding about who is the creditor, what does it mean to be a creditor, who can collect payments, who cannot collect payments. If you're reporting on my credit and you're not the creditor, that's against the law, right? Like all of these things are interconnected. All of them. Anyways, y'all have a good Easter Sunday, and I'll catch up with y'all real soon.